ahead and share the screen sorry. Great. Hello and welcome, everyone. My name is Courtney Velasquez, and I'm an engagement specialist with the Seattle Office of Labor Standards. I'm joined today by two of my colleagues who will now introduce themselves. Lane, sorry.
Hi, I'm Lane Midda. I'm a policy analyst at OLS.
Hi, and I'm Mark Rose. I'm a labor standards investigator at OLS.
Thank you. We are here today to explain Seattle's Independent Contractor Protections Ordinance that went into effect on September 1st, 2022. We'd like to remind you that this training is for informational purposes only and does not serve as legal advice of any kind. If you do need legal advice, please consult an attorney. The mission of the Seattle Office of Labor Standards is to advance labor standards through thoughtful engagement with community and businesses, strategic enforcement, and innovative policy development, all with a commitment to race and social justice. OLS currently enforces 17 ordinances or laws. Please note that the premium pay for grocery employees, so that's listed here as number 14, the premium pay portion of that law is no longer in effect, but the rights that did exist under the Grocery Employee Hazard Pay Ordinance are still enforceable for 3 years. Sorry. As we mentioned, today we'll focus on the 17th, or the most recently enacted or implemented ordinance, the Independent Contractor Protections, which as of September 1st of 2022, independent contractors in Seattle now have the right to know what they're going to be paid before they start work, and the right to be paid on time with an itemized pay stub or receipt. And this is to ensure that independent contractors are paid what both parties, what they and the hiring entities originally agreed to. Lane will now take us through to talk about what the law covers.
Thank you, Courtney. This law covers contracts for services between businesses and independent contractors. It does not apply to the sale or purchase of merchandise. And it applies to relationships where the independent contractor is paid at least $600 or can expect to be paid at least $600 over the course of a year. These are contracts between independent contractors, and I will explain a little bit more detail what that means in this ordinance, and commercial hiring entities. So this is not to cover all contracts between businesses and other businesses, just between independent contractors and commercial hiring entities. So an independent contractor under the Independent Contractor Protections Ordinance is an individual that's hired by the business as a self-employed person or entity to provide services for compensation. So this is a person or entity composed of no more than one individual. So if a contractor has employees, they would not be considered a single individual and an independent contractor under this ordinance. Independent contractors that are covered under this ordinance perform their work in either in whole or in part, and the hiring entity must know or have reason to know that that work is being performed at least partially in Seattle. So coverage for under ICP is all or nothing. So if any part of the work is performed in Seattle and the hiring entity knows that that work is being at least partially performed in Seattle, then the entire contract is covered under the law. The Independent Contractor Protections Ordinance covers independent contractors in all industries across all kinds of different professions. There are only two exceptions in the law. One is lawyers who are engaged in the practice of law for the services that are being considered. And the other exemption is for transportation network companies or rideshare drivers like Uber and Lyft, and regulations around those contracting arrangements are covered under state law. Other app-based workers, delivery drivers, and other workers who who get their work through an app are covered as if they meet other coverage requirements like the $600 threshold. And there may be some overlapping rights for independent contractors under pay up minimum compensation language or legislation. Just to note, the contracts for those app-based workers, that typically is between the app itself and the worker, because that's the relationship where the terms and conditions of the work are being determined and agreed upon, not a user who is purchasing services through an app. A commercial hiring entity under this ordinance is one that is regularly engaged in business or commercial activity. So this is distinct from a domestic household, for example. This includes not-for-profit businesses and can cover any range of trades, occupations, and businesses. Purely domestic household and hiring entities, households are not covered. But there may be instances. So for example, if a household hires an independent contractor who is a plumber to come and fix the toilet for their own home, then that is not covered by ICP. But if the homeowner rents out that home for Airbnb or for some other business purposes and hires that same self-employed plumber to fix that toilet, then that would be covered because that individual is hiring, or that homeowner is hiring the independent contractor in the course of business activity.
Next, we'll transition to talk about what the law requires. So the basic requirements of the Independent Contractor Protections Ordinance are four things. Businesses or commercial hiring entities must provide independent contractors with a notice of rights under the ordinance before work begins, a pre-work written notice that identifies the terms and conditions of work and the terms and conditions of payment, all in a single document before work begins. Timely payment according to the terms and conditions of the pre-work written notice, or if it's not specified, then within 30 days after work is completed. And a written notice that gives specific itemized payment information each time payment is made to the independent contractor. And this would be similar to an employee pay stub. OLS has a webpage for the ICP ordinance with links to key documents, including the ordinance itself, rules and complaint procedure, and the 3 model notices, and a fact sheet, as well as the question and answer guide. Here's what the ICP model notice of rights looks like. This law protects independent contractors covered by the ordinance regardless of immigration status. Hiring entities must provide the information included in the model notice of rights to independent contractors before work begins. This notice must be given in English and the worker's primary language in hard copy or electronic format that is accessible. And the model notice of rights has a QR code right here in the lower right corner that will take you to the ICP webpage, this page that we just looked at directly. The pre-work written notice is a sample form. Commercial hiring entities are not required to use the OLS form, but they must provide the required information. This written notice must be given in English and the primary language of the independent contractor. The sections include independent contractor and hiring entity information, the location or locations of work, description of work or services that the independent contractor will provide, including all terms and conditions that the hiring entity requires to be met before payment is made. And finally, specific information about payment. And so the payment section covers the rate or rates of pay, the pay basis, and the payment schedule, any tips and service charge policies, if applicable, typical costs associated with the work, and identifying if those costs will be paid for by the hiring entity, reimbursed by the hiring entity, or if the costs will be assumed by the independent contractor. Also, identifying any deductions, fees, or other charges that will be subtracted from the payment, and also providing the policy for each of those deduction fees or other charges, if applicable. And finally, attaching any additional terms or conditions as applicable. Mark will talk about what if there's no pre-work written notice?
That's a good question. If there's been no pre-written work notice, then the ordinance has put in place some teeth with the hope of incentivizing the hiring entities to comply. So if there was none, but there is an agreement for services that are covered by the ordinance, meaning like here a verbal agreement, for example, to provide services, and the independent contractor performs the agreed work, and the hiring entity didn't provide the pre-work written notice, then the law is going to presume that whatever the independent contractor alleges are the terms of the party's agreement, that they are in fact the terms. And so the independent contractor's alleged terms may end up filling in the gaps on a number of things. For example, what was the exact scope of work? Was the contractor to build one fence or five? How much are they going to get paid for the work? Was there an hourly rate that was $15 or was it $17? And when are they going to get paid, for example? Will they get paid upon completion or in 2 weeks? Any of those kinds of gaps and other things can be filled in by the independent contractor's allegations if the hiring entity hasn't put in place the written pre-work notice. So the law states that this kind of presumption is going to apply not only in one of the Office of Labor Standards investigations, but it can also apply in any civil action that gets filed by the contractor. So if the contractor has to file a lawsuit either under this law or for breach of contract, their allegations may govern what the terms of the contract were, and the hiring entity would only be able to rebut that kind of presumption through some kind of clear and convincing evidence like a written contract.
Thank you, Mark. The written notice for itemized payment information is also a sample form. Commercial hiring entities are not required to use the OLS form, but they must provide the required information. This written notice must be given in English and the primary language of the independent contractor each time payment is made. Payment must meet the terms and conditions agreed to by both parties in the pre-work written notice. And the written notice for itemized payment information must include the date, the names for both parties, description of the work covered by the payment, the locations of work covered by the payment, and itemized payment information that specifically must identify the amount and list a description or calculation that explains the amount for each type of payment as applicable. Again, this information must relate to the terms and conditions agreed to in the pre-work written notice. That is, the payment by rate and basis, and this refers to any base payments plus any commissions, bonuses, etc. as applicable. Also as applicable, any tip payment, service charge payment, and or cost reimbursements. The payment information must also identify the gross payment amount, and then any deductions, fees, or other charges that are subtracted, if applicable, and finally, the net payment total. Each of the 3 ICP model notices that we just walked through are currently available in 13 languages and are posted to OLS's resources and language access web pages. We encourage hiring entities to contact OLS if additional language translations are needed. The estimated turnaround time is about 2 weeks. Mark?
So the remedies that would be available to independent contractors if there is a violation of this law include a lot of the types of remedies that we see under the other Seattle labor ordinances. For example, if there is a dispute about whether they were paid the right amount, the independent contractor can seek unpaid compensation. They can also seek interest on the unpaid compensation, as well as a category of damages that we call liquidated damages, which essentially means another bucket of money that would be twice the amount of the unpaid compensation. There's also provision for civil penalties for violations of the law, as well as a series of different types of fines, depending on the types of violations. And I think as we referenced, there is a right to file a civil lawsuit if the worker decides to do that. And if they, under this law, and if they do, there's the allowance for attorney's fees that could be collected under the law.
Who can you contact for technical assistance? Hiring entities may contact OLS to request translations of model notices, assistance with compliance, or training. OLS's business inquiry staff may be reached via our office phone that's listed here, our email at business.laborstandards@seattle.gov, or via the employer inquiry form on our website. Independent contractors or workers may contact OLS to ask a question or to file a complaint. OLS's worker inquiry staff may also be reached via our office phone, via the email at workers.laborstandards@seattle.gov, or via the worker inquiry form, also on our website. Specifically talking to workers. So workers, if you believe that you are an employee instead of an independent contractor, OLS may be able to assist you. As an employee, you may have rights to paid sick leave, minimum wage, overtime, and paid meal and rest breaks. Please review OLS's worker classification guide on our website before contacting us. Please also note that exercising rights under the Independent Contractor Protections Ordinance will not affect any rights a worker might have as an employee. Now we will look at some common questions. I'll hand it over to Mark.
So one of the questions that you may be thinking is, what if an independent contractor has employees? The plumber we talked about earlier. If the plumber has some other people that they employ, maybe a small team of just 2 plumbers, let's say, is that person, when they're called in, an independent contractor that's going to be covered by this law? Let's see, what's the answer? No. An independent contractor, as defined in this law and for purposes of coverage under this law, means that the person has no employees. So if the plumber has any employees, they're not going to be considered an independent contractor, regardless of whether or not they're going to go service an Airbnb or not. But if they are a self-employed person with no employees, then they would be covered. Here's another common question. Well, here's a question that it's not perhaps common, but it's a scenario that really helps us understand the law. Let's think about a corporate event planner. So somebody who's going to plan an event for a business in town. And if that corporate event planner is hired to put on an event and they have a subcontract with a DJ who will be performing at the event, what do we consider the corporate event planner? So they've been hired by a business. They have no employees, let's say, and then they subcontract. Are they an independent contractor in this scenario, or are they a hiring entity? Well, it's a trick question. The corporate event planner in this scenario would be both. They would be an independent contractor as to the business that's hired them to put on the event. And then they'll have rights as an independent contractor under our law there, assuming that there's coverage requirements met, like we've talked about, the $600 compensation, for example. And separately, they would be considered a hiring entity in terms of their relationship with the DJ, assuming again that the DJ is making enough money, or through a series of contracts with the same corporate event planner over the course of a year would be expected to earn $600.
Another question we've heard a lot is whether or not a hiring entity or a business can use a contract that was written by the independent contractor as a pre-work written notice. Sometimes a business says, well, do we have to write up our own pre-work written notice? We already have this contract that we've hammered out or that the independent contractor has provided to us. The answer is that a business can use the contract as the pre-work written notice. It doesn't matter who wrote the document in the first place, as long as the hiring entity or the business makes sure that the document includes all the required information. If the contract or the bid document or whatever document they're received from the independent contractor does not include all of the required information, they can write an attachment. They can attach any additional information that is missing in order to comply with the law. But it is the business's or the hiring entity's responsibility to make sure that all of the required information is included in that document. Similarly, for the payment notice, can an invoice or a bill from the independent contractor count as a payment disclosure? Again, the hiring entity or the business can use the invoice and can use the invoice as a written payment disclosure or reference the invoice, but it is still the hiring entity or the business's responsibility to include any additional required information. But it doesn't matter who generated the invoice or the contract, who wrote the document in the first place.
Just a reminder that on our website, we do have a question and answer guide that addresses these common questions and others. And then we will also be looking to this and may update it in the future with additional questions that we receive. But to begin with, the question and answer guide goes through the content that we covered in more detail, as well as some other common questions. I want to thank you for joining us today for this recorded webinar. If you want to know more about the Seattle Office of Labor Standards and all of the other ordinances, in addition to the Independent Contractor Protections Ordinance, please go to our website. You can also sign up for newsletters there to be on our mailing list to receive up-to-date information and press releases. Thank you very much.